We are starting our second class for revision purpose. In the very first class, we have seen the Indian Constitution, judicial system. Then we have seen how Indian Constitution is federal and meaning of federal. Then we have seen the 5th schedule, 10th schedule and the 11th schedule. Then we have seen the Constitution is the largest written constitution. Then we have seen the idea of Constituent Assembly, M.N. Roy, and the stand of Pandit Nehru, and by the August offer, the Britishers accepted the demand of Constituent Assembly. Then we have seen the Keshavananda Bharati case, in which Supreme Court said that preamble is part of the Constitution. And the last topic which we saw was the Constitution, adoption of the Constitution. We adopted our Constitution in 1949, that is 26th November 1949. Then let us continue the important topics which we are continuing. Next, the 11th topic which we are going to start is the polity, the democratic polity. What is the democratic polity? The democratic polity can be explained in terms of two methods. One is your monarchy and one is your republic. So whenever a monarchy, the republic will be, whenever there is a monarchy in which a country, a democratic country in which monarchy exists. Example, we have Britain and Japan. In that country, they are all democratic country, but the head of the state is a queen or a queen. Example, British and Britain and Japan. And a democratic country who is a republic, example, India. A republic means vesting of all political sovereignty in the people and not a single individual. So in our India is a, as our preamble says, India is a sovereign, socialist, secular, democratic republic, which means that India is headed by a elected head. Vesting of all political sovereignty in the people and not in single individual. And it also means that absence of any privileged class, and hence all public offices will be open to public without any discrimination. Next, let us discuss the Constituent Assembly. Now we have seen in our previous session, the first we have understood that the first Constituent Assembly was formed pre-partition. The first session of the Constituent Assembly was held on 9th December 1946, that is before the partition. Now let us look at the structure. Let us look at the structure and the strength of the Constituent Assembly. The total strength of the Constituent Assembly was 389. Please write it down. Whoever is watching this video online as well as offline, the total strength of the Constituent Assembly was 389. And out of this 389, if we see the arrangement, the 296 were to be allotted to British India and 93 seats to be the princely states. And each province and princely state were to be allotted seats in proportion to the respective population. Now please remember, the basis on which each seat was allotted was the population. At that point of time in 1946, each seat for every 10 lakh population, one seat was allotted. So this was the arrangement. This is one of the previous questions in LAWCET' as well as UPSC as well as groups. In 1946, when the Constituent Assembly came into existence, what is the arrangement of the seats? For every 1 million population, that is 10 lakh, one seat was allotted in the Constituent Assembly. So this you have to remember. Now we can also say that the Constituent Assembly was a partly elected and partly nominated body. So this was all about the Constituent Assembly. Now let us talk about the preamble. Now let us talk about the preamble. The first preamble is now the origin on December 13, 1946. Please remember, December 13, 1946, Jawaharlal Nehru moved the objective resolution. Today we call it as preamble of our constitution. Now, on December 13, 1946, Jawaharlal Nehru moved the historic objective resolution in the Constituent Assembly. So, Jawaharlal Nehru moved the historic objective resolution. The objective resolution is the original name of the preamble. What does the objective resolution consisted of? Objective resolution consisted of fundamentals and philosophy of the constitutional structure. Now, this objective resolution was passed unanimously by the Constituent Assembly on January 22, 1947. Now, please remember the date on which the objective resolution was passed was December 13, 1946, and it was adopted unanimously without any objection on January 22, 1947. These two dates are very important. What is the significance of the objective resolution? As per the objective resolution, it shaped the constitution throughout its subsequent stages. Now, modified version of the preamble of the present constitution. So, as we know that there are three cases when we are discussing about the preamble. There are three cases. The very first case, the Berubari Union case, which happened to be in 1960. The Supreme Court said that preamble is not part of the constitution. Now, when it comes, the question again raised in the Supreme Court in 1973 in the Keshananda Bharati case. Supreme Court reversed its stand and said that preamble is part of the constitution. Now again in 1995 in the LIC case, Supreme Court not only said that preamble is part of the constitution, but it said that it is an integral part of the constitution. So please remember the original name of the preamble is objective resolution. It was moved by Jawaharlal Nehru on December 13, 1946. It was passed by Constituent Assembly on January 22, 1947. And the current condition is that the preamble is an integral part of the constitution as said by the Supreme Court of India. Next we have, let us understand the evolution of the constitution. Now when we see the evolution of the constitution evolution in the Indian constitution history started with the Regulating Act of 1773. Then we have Amending Act of 1781. Then we have Pitt's India Act of 1784. Then after that we have 4 Charter Acts, that is Charter Act of 1793, 1813, 1833 and 1853. Then in 1858 we have Government of India Act, then the Councils Act, 1861, 1892, then 1909, 1919 and 1935. The act through which the final act in the series of historical evolution is the Independence Act of 1947. The Independence Act of 1947, which was passed with the British Parliament, gave India the independence it wanted. Now, the Independence Act of 1947 made 3 changes in the position of Constituent Assembly. Now, please remember that the Constituent Assembly was formed on the basis of Cabinet Mission. Which came in 1946 to India. Now, once this Indian Independence Act was passed, we have 3 changes. What are the 3 changes? The Assembly gained complete control over the drafting of India's constitution and could modify or abolish any British law. Now, this one thing is very clear. As per the Independence Act of 1947, the power was given to Assembly that it can draft any constitution for independent India. Second, then as you know that the full strength of the Constituent Assembly was 389. It was before the partition. Now after the partition, the strength of the 389 became 299. As we know that the Muslim League Party were formed the Pakistan and their members were deleted from the Constituent Assembly strength. Now, previously for the princely states, 296 seats were given. It got reduced to 229. And for the British provinces, they were given 296. but it got reduced to 299, 229, and the princely states were given 93. They got it reduced to 70. Now, as you can say that when we are understanding the Constituent Assembly had two roles. That is a constitution making body and also the provincial government, provincial parliament, passing laws for the new nation. Now, Constituent Assembly had two roles. One, it was to make the constitution making body, as well as it acted as provincial parliament. It acted as provincial parliament. So this was about your Constituent Assembly. Now what is the role of Constituent Assembly? What is the role of Constituent Assembly? Now, as we have already discussed, Constituent Assembly was responsible for making ordinary laws and drafting the constitution. For making ordinary laws, it acted as provisional parliament, and to draft the constitution. As we know that in the Constituent Assembly, drafting was done. The drafting committee was made. The head of the drafting committee was B.R. Ambedkar along with other members. Now, most important 3 to 4 dates you have to remember is that the very first thing Constituent Assembly did was Constituent Assembly ratified the membership of Commonwealth in May 1949. What was the Commonwealth? Britishers were a colonial power. It colonized almost all the countries. Now, what did the Britishers did? They combined all the colonized countries into a group and they gave it as the name of Commonwealth. So the very first thing the Constituent Assembly did was to ratify the Commonwealth membership, India's Commonwealth membership in May 1949. Please remember, these dates can come arranged the following in a chronological order. What is the first session of the Constituent Assembly? When did the first session of the Constituent Assembly happen? 9th December 1946. Then in May 1949, it ratified the India's membership in the Commonwealth. Second, in July, it adopted the national flag. In July 22, on July 22, it adopted the national flag. July 22, 1947. And it adopted the national anthem on January 24, 1950. So please remember the most important dates. In first session was 9th December 1946. It ratified the Commonwealth membership in May 1949. It adopted the national flag on July 22, 1947. Adopted the national anthem on January 24, 1950. It adopted the national song on January 24, 1950. So the date on which there was the same date on which the national song as well as national anthem was adopted was January 24, 1950. And it elected Dr. Rajendra Prasad as the first president of Republic India on January 24, 1950. So 3 dates are very same. Please remember. Okay. So we completed the Constituent Assembly and its important dates. Now let us, after understanding the Constituent Assembly, let us understand the sources of the Indian Constitution. Let us understand the sources of the Indian Constitution. The very first source of the Indian Constitution is the Government of India Act 1935. Now please remember, Nehru during the 1935, during the freedom movement, Pandit Jawaharlal Nehru commented that this Government of India Act 1935 as an act of slavery. So let us see what are the provisions which we got inspired from Government of India Act 1935. Now please remember, I am repeating it, telling it to twice or thrice so that it will etch to your mind. From the Government of India Act 1935, we took federal scheme, that is the distribution of powers, office of governor. Now please remember, from the Government of India Act 1935, we took the office of governor. Judiciary, concept of judiciary. Now please remember, independence of judiciary we have taken from USA. Independence of judiciary we have taken from USA. But the concept of judiciary is taken from the Government of India in 1935. Then we have took the Public Service Commission, the TSPSC which we are having now, the UPSC has been taken from Government of India in 1935. Emergency provisions. What is the emergency provisions? We have national emergency, we have state emergency, and we have financial emergency. Please remember the only the emergency provisions has been taken from Government of India Act 1935. The suspension of the suspension of application of fundamental rights has been taken from German Constitution. That is the Weimar Republic. So please remember, from the Government of India Act 1935 we took federal scheme, office of governor, concept of judiciary, public service commissions, emergency provisions. Emergency provisions in our constitution are 352 national emergency, 356 state emergency, that is the president rule. In officially it is a breakdown of official constitutional machinery. Then we have the article 360, that is financial emergency, and the administrative details which we have taken from the Government of India Act 1935. Now let us look at what we have taken from British Constitution. Now please remember, we have British common law. The Britain does not have any constitution till date. Their system of working is called as common law, means judgment law. Now from the British common law we have taken the parliamentary government. We have taken the concept of parliamentary government, rule of law. We have taken rule of law, legislative procedures, single citizenship, cabinet system. We have taken the cabinet system. We have taken prerogative rights. So under our article 32 of the Indian Constitution of India, we have 5 rights. What are the 5 rights we have? They are called as prerogative rights: habeas corpus, mandamus, prohibition, quo warranto, and certiorari. These are the 5 rights we have taken from the British common law system. Then we have parliamentary privileges and bicameralism. What is the bicameralism? The concept of having 2 houses. One is the lower house and one is the upper house. So what we have taken from the British common law system? Parliamentary government, rule of law, legislative procedure, single citizenship, cabinet system, prerogative rights, the 5 rights, that is habeas corpus, mandamus, prohibition, quo warranto, and certiorari under Article 32 of our Constitution of India, parliamentary privileges and bicameralism. Now let us look at what we have taken from the USA's Constitution. Now USA's Constitution, fundamental rights. We have taken the concept of fundamental rights. Now in USA they call it as Bill of Rights. The similar concept has been emulated by Indian constitution makers, that is in the name of fundamental rights. Then independence of judiciary. The concept of judiciary is taken from Government of India Act 1935. The independence of judiciary has been taken from USA's Constitution. Now we have discussed in the previous class what do you mean by independence of judiciary. Then the concept of judicial review. The judicial review in our Constitution is under article number 13 of the Constitution of India. Impeachment of the President means the removal of a constitutional authority, that is the President. Removal of Supreme Court and High Court judges. And the most important part, the post of Vice President. In USA, Vice President is called as running mate. The Vice President is called as running mate. Now let us look at what are the provisions we have taken from Irish Constitution, that is Ireland. We have taken the directive principles of state policy. In our Constitution of India, the directive principles of state policy has been taken from, is incorporated in part 4 of the Constitution of India, and it has been taken from Ireland. Nomination of members to Rajya Sabha. The concept, the provisions taken from the Irish Constitution are DPSP, that is Directive Principles of State Policy, nomination of members to Rajya Sabha, and method of election of president. Method of election of president has been taken from Irish Constitution. Let us look at the Canadian Constitution. What are the provisions we have taken from the Canadian Constitution. From Canadian Constitution, we have taken first point, federation with a strong center. Now, as you know that when we became independent, we were a fledgling nation, very weak nation. So it was important to keep the union, keep the center very strong with a federation. Then we have residuary powers in the center. Please remember residuary centers. As we have the schedule 7, we have 3 lists. One is a union list, state list, concurrent list. What are the entries which doesn't come in this 3 lists are called as residuary powers. Then whatever doesn't come under 3 lists, they are given to the center, that is the parliament. Now we have appointment of state governors by the center. Okay. Now remember, office of the governor has been taken from Government of India Act 1935. The post of the governor has been taken from the appointment of the governor has been taken from the Canadian Constitution, and the advisory jurisdiction of the Supreme Court. Now please remember that advisory jurisdiction of the Supreme Court is given under the Union Judiciary provisions of the Constitution of India. Then we have Australian Constitution. What are the topics which we have taken from Australian Constitution? Concurrent list. The very first topic we have taken from Australian Constitution is the concurrent list, freedom of trade, commerce and intercourse, and a joint sitting of the 2 houses of the Parliament. Now please remember, concurrent list is a list 3 under Article 246 of the Constitution. Then we have joint sitting of the 2 houses of the Parliament. The article in our Constitution for joint sitting is Article 108. Article number 108. Now look at the Weimar Constitution of Germany. We have taken the concept of suspension of fundamental rights, suspension of application of fundamental rights during emergency. The emergency provisions has been taken from the British Constitution. Please remember, Government of India Act 1935. But the suspension of the fundamental rights during emergency has been taken from the Weimar Constitution of Germany. Then let us look at what we have taken from USSR, that is present Russia. We have taken the concept of fundamental duties, that is part 4A in our current constitution, and the ideals of justice, social, economic and political in our preamble. So from USSR we have taken 2 concepts. One is fundamental duties and the ideals of justice, that is social, economic and political in the preamble. French Constitution. When you look at the French Constitution, we have taken republic and ideals. Republic and ideals of liberty, equality, fraternity in our preamble. As we know that we are a republic, democratic republic country. Our head of the country is an individual who is selected by the common people. So from French Constitution we have taken the word republic, liberty, equality and fraternity in our preamble. And the last but one, South African Constitution. We have taken many concepts from the South African Constitution, such as procedure for amendment of the Constitution. Now in which article does the procedure for amendment of the Constitution is given? It is under article number 368. Please remember, in our Constitution, the powers and procedure to amend the Constitution has been given in under article 368. Which concept has been taken from South Africa? And the election of members of Rajya Sabha has been taken from the election of members of Rajya Sabha. The method has been adopted from South African Constitution. Last but not the least, we have taken from Japanese Constitution, procedure established by law. So the rule of law, please remember, rule of law has been taken from Britishers. Then the procedure established by law has been taken from Japanese Constitution. So please do not get confused. So by this we complete about the sources of Indian Constitution. Now let us look at the preamble. Now look at the preamble. As we know that the original name of the preamble is Objective Resolution. It was moved by Pandit Nehru and passed by the Constituent Assembly. Now, how many times, the very common question in a very competitive examination, how many times our preamble has been amended? As we know that the preamble has been amended only once. The preamble has been amended only once. That is during the 1976 Indira Gandhi government, the 42nd Constitution Amendment Act 1976. Through this amendment, three words were added into the preamble. One was socialist, second was secular, and the third is the word integrity. So our preamble has been amended only once, that is the 42nd Amendment Act 1976 during the Indira Gandhi time. Please remember. Now, the concept of secularism in India. The word secular has been added in our preamble. We have emulated the concept of secularism in a very positive way, and it has been inspired. We have a secularism, we have a positive form of secularism, and it has been inspired from the Europe. It has been inspired from the Europe, in which they practice the negative form of secularism. Now, when we say that we practice positive form of secularism, it means that we have a multi-religious society. And we don't have any state religion. It is called as positive form of secularism. Now, let us look at some of the committees of the Constituent Assembly. As we have already seen, let us revise. Union Power Committee was headed by Jawaharlal Nehru. Union Constitution Committee was also headed by Jawaharlal Nehru. Provincial Constitution Committee was headed by Sardar Patel. Drafting Committee was headed by Dr. B.R. Ambedkar. Advisory Committee on Fundamental Rights, Minorities and Tribals and Excluded Areas were headed by Sardar Patel. And the next is Rules of Procedure Committee was headed by Rajendra Prasad. Now let us look at one of the most important topic, that is the Drafting Committee. As we know that Drafting Committee is one of the major committees of the Constituent Assembly. It was formed on August 29, 1947. The concept of the Drafting Committee was formed on August 29, 1947. The chairman of the Drafting Committee was Dr. B.R. Ambedkar, along with other members such as N. Gopalaswamy Iyengar, Dr. K.M. Munshi, then we have Syed Muhammad Sadullah, then we have Alladi Krishnaswamy Iyer, then we have N. Madhav Rao, which he replaced D.L. Mittal, who resigned due to ill health. Then we have T.T. Krishnamachari, he replaced D.P. Kaithan, who died in 1948. Now, the Constituent Assembly took a complete period of 2 years, almost 2 years, 11 months and 18 days to complete the Constitution. And it gave 8 months to public to give their opinion. And the Drafting Committee, the initial draft was presented in February 1948. So by this, we complete our major concepts for today, and we conclude our class today. So by this, we have completed the 20 concepts of the basic constitution history. Tomorrow in the morning session, we will start for groups, we will start the history, and in the evening we will continue with our constitution. Thank you.